Today, we're diving into one of those essential topics that touches nearly everyone at some point in their life: landlord-tenant laws. Whether you're renting out a space or living in someone else's home, understanding these rules can make all the difference in avoiding disputes and ensuring everything runs smoothly. So let's start with the basics. What are landlord-tenant laws? These are regulations that govern the relationship between landlords and tenants. They cover everything from how much notice you need to give when ending a lease, to rules about security deposits and maintenance responsibilities. In many places, there's a specific set of laws that apply no matter where you live, but there can also be local ordinances that add extra layers to these rules depending on the city or state. For example, in most states, landlords have to provide habitable living conditions, meaning safe heating, plumbing, electricity, and structural integrity. This is one of those non-negotiables that must be met for a tenant to live there comfortably. Another key aspect is security deposits. These are typically refundable amounts held by the landlord until the lease ends without damage beyond normal wear and tear. There might be limits on how large these deposits can be, and rules about when they have to be returned, usually within 14 to 30 days after move-out. Then, there's the nitty-gritty of eviction procedures. Landlords can't just throw a tenant out whenever they want. They need to follow specific steps, including giving notice and going through legal channels if necessary. For tenants, being late on rent or breaking lease terms might trigger these procedures, but landlords must still adhere to due process. Lease agreements are also covered under landlord-tenant laws. These contracts outline everything from payment schedules to rules about pets or smoking. Both parties need to review these carefully before signing them, as any misunderstandings can lead to disputes later. Another important point is that tenants have certain rights too, beyond just receiving a safe living space. Many places require landlords to make repairs in a timely manner and give notice before entering the property for non-emergency reasons. All of this shows how landlord-tenant laws play an important role in protecting both parties' interests and ensuring fair treatment throughout the rental process. Whether you're renting out a high-ticket apartment or living in someone else's place, knowing these rules can make all the difference in avoiding disputes and maintaining positive relationships between landlords and tenants. So there you have it, a quick overview of some key points to consider when dealing with landlord-tenant laws. Today, we're diving into an important topic for both landlords and tenants: understanding tenant rights and responsibilities. Let's start by looking at what these terms mean in the context of renting. Tenant rights refer to legal entitlements that protect tenants from unfair treatment or unsafe living conditions. These include things like receiving a habitable home, privacy, and the right to live without discrimination. On the flip side, tenant responsibilities are duties they must fulfill to keep up their end of the rental agreement. Now, let's break it down further. Tenant rights can vary by location, but many areas have similar protections. For example, every tenant has the right to a home that meets basic safety standards and isn't infested with pests or mold. They also deserve privacy, meaning landlords shouldn't enter their unit without notice unless there's an emergency. Another important right is freedom from discrimination based on factors like race, gender, religion, or disability. Alongside these rights come responsibilities for tenants to uphold. Paying rent on time is one of the biggest ones. This keeps the landlord financially stable and helps avoid late fees or legal actions. Tenants are also responsible for taking care of their space by not causing damage beyond normal wear and tear. This means things like keeping the apartment clean, disposing of trash properly, and using appliances correctly. It's important to note that both sides have roles to play in maintaining a positive rental experience. Landlords need to be responsive to maintenance requests and repairs, while tenants should communicate clearly about any issues they encounter. Building this rapport can lead to long-term successful rentals where both parties feel respected and valued. So, what happens if these rights or responsibilities aren't met? Well, there are legal avenues available for resolving disputes. For example, A tenant might file a complaint with local housing authorities if the landlord fails to make necessary repairs. Or landlords may seek legal action against tenants who repeatedly violate lease agreements by paying rent late or causing significant damage. To sum up, understanding both tenant rights and responsibilities is key to having a fair and positive rental experience. By knowing what you're entitled to as a tenant and what obligations come with renting, you can better navigate the complexities of leasing a home. Welcome back to our class on rental agreements. Today, we're diving into understanding different types of rental agreements you might encounter. So let's jump right in. First up, we have the fixed-term lease agreement. This is where both parties agree to a specific start and end date for the tenancy. It's perfect if you're looking for stability or planning ahead for something like starting college next semester. Now, this type of agreement usually has more detailed terms compared to others because it locks everything in stone for that set period. Next up is the periodic rental agreement. This one is pretty flexible and doesn't lock you into any specific term. It typically runs month to month, but can also be week to week or even day to day depending on what's negotiated between landlord and tenant. The beauty of this agreement is its flexibility. It suits those who might need to move around a bit more, like someone working in construction or the travel industry. Then, there's the lump sum rent agreement, which is less common but still worth mentioning. It's where you pay for multiple periods upfront, such as paying 6 months' rent at once. This can sometimes offer discounts and makes budgeting easier, but it does tie up your cash flow more than paying monthly. Let's not forget about the high-ticket item rental agreements like those used for commercial spaces or vacation rentals. These often come with specific clauses addressing business operations or seasonal use, which are negotiated to fit those unique needs. Lastly, we have a sublease agreement where you lease out part of your space to another tenant while still being responsible to your landlord. It's a great option if you need short-term accommodation or want to bring in some extra cash from renting out your spare room. So there you have it, the main types of rental agreements explained. Each has its pros and cons depending on what kind of lifestyle you're leading or planning for the future. Remember, understanding these options will help you choose wisely when deciding where to call home next. Thanks for joining me today, and I hope this gives you a clearer picture of your rental agreement choices. So today, we're diving into the world of lease agreements and how to create one that covers all the bases. Whether you're renting out your basement apartment or leasing commercial space for a business, having a solid lease agreement is key. Let's start by understanding what exactly goes into a comprehensive lease agreement. First things first, it's important to define who the parties are: the landlord and tenant, or lessee and lessor in more formal terms. This might seem obvious, but making sure everyone knows who they're dealing with upfront saves headaches later on. Next up is specifying the leased property. Describe where exactly the leased space is located and its physical characteristics, like square footage or room numbers if it's part of a larger building. Be as detailed as possible here because this will serve as your blueprint for resolving any disputes that may arise in the future. We also need to nail down how long the lease lasts, whether it's month to month, year to year, or some other duration. It's crucial to include start and end dates so there's no confusion about when rent is due or when the agreement expires. Now let's talk about rent payments. This includes specifying the amount of rent, how often it gets paid weekly, monthly, when rent should be delivered, like by what date each month, and late fees if applicable. Also, consider including a method for adjusting rent over time, especially useful in commercial leases where market conditions can change. Security deposits are another key aspect. Specify exactly how much the tenant needs to pay upfront as security deposit, and under what circumstances it will be returned. It's important here to mention that this deposit is not rent, but rather a safeguard against damages or unpaid rent. Maintenance responsibilities need to be clearly defined too. Decide whether the landlord will handle all repairs or if certain maintenance tasks fall on the tenant. Be specific about who pays for utilities and what those utilities are: electricity, water, internet. Also worth mentioning is how any alterations or improvements to the leased property will be handled. Will the tenant be allowed to make changes? If so, do they need prior approval from the landlord? These details are important because they can impact how much wear and tear there is on the property over time. Insurance requirements should also be addressed. Usually both parties have some kind of insurance coverage that needs to be maintained during the lease period. It's a good idea for tenants to carry renters' insurance in residential leases, while commercial leases might require more specific types of coverage like general liability or business interruption insurance. Lastly, include provisions about subleasing or assigning the lease if necessary. This can give flexibility to both parties, but it's important that any such transfers are done with consent from all involved and according to local laws and regulations. All these components come together to form a robust lease agreement that protects both landlord and tenant. It's worth taking your time and consulting legal professionals if you're not sure about certain aspects or the wording of clauses, because getting it right up front saves trouble down the line. So there you have it. Creating a comprehensive lease agreement is all about covering every detail to ensure smooth sailing for everyone involved. Let's dive into something really important for landlords and tenants alike: legal requirements for security deposits. It's crucial to understand these rules to avoid any misunderstandings down the line. First off, let's talk about what a security deposit actually is. It's money that a tenant pays upfront to cover potential damages or unpaid rent at the end of their lease term. But here's the kicker: how you manage this fund can get pretty tricky. Now, state laws vary widely when it comes to security deposits. Some states have specific rules about how much you can charge and what happens if there's a disagreement over deductions from the deposit. For example, in California, landlords must provide an itemized list of deductions within 21 days after the tenant moves out. In New York, however, landlords typically have more flexibility regarding the amount they can charge, but must return any remaining balance promptly. Another key aspect is how you handle the money itself. Some places require it to be held in a trust or escrow account until it's time to return it, while others might allow you to keep it in your regular bank account, but clearly marked as tenant funds. Make sure you know what applies where you operate. Then, there's the issue of returning the deposit once the lease ends. You usually have a certain period to return it, often within 14 or 30 days, depending on local laws. It's important to stay within these timelines to avoid disputes or legal troubles. Now, let's not forget about documentation. Keeping detailed records is critical. Have signed agreements outlining deposit amounts and terms of use. Also, make sure you do a thorough move-in inspection so there are no surprises later when it comes time to deduct for damages. All right, wrapping up here: knowing the legal requirements for security deposits can save you lots of headaches down the road. Just remember, check your local laws, manage funds responsibly, stick to timelines, and document everything clearly. Let's dive into how to handle deposit disputes effectively. When you're dealing with customers who are unhappy about their deposits, it can feel overwhelming, but there are clear steps you can follow to make things right. Firstly, always start by listening carefully to the customer's concerns. Take notes and ask clarifying questions if needed. This shows them that you care about resolving their issue. Next, review the deposit policies in your contract or agreement with a fine-tooth comb. Look for any specific clauses that might apply to this situation. Once you've understood both sides of the story, it's time to determine whether the dispute is valid. If there are discrepancies or misunderstandings, try explaining things clearly and calmly. Sometimes, simply clarifying expectations can resolve the issue. If the deposit needs to be adjusted or refunded, do so promptly and professionally. Letting customers know when they can expect their refund helps maintain trust and goodwill. Remember, transparency goes a long way in these situations. For more complex disputes, consider involving a third party such as an arbitrator or mediator. They can provide an unbiased perspective and help reach a fair solution for both sides. Lastly, Always follow up with the customer after resolving the dispute to ensure they're satisfied with the outcome. This reinforces your commitment to customer service and builds trust for future dealings. Handling deposit disputes effectively is all about clear communication, empathy, and decisive action. By addressing issues promptly and professionally, you can turn a potential negative into a positive experience for both you and your customer. Okay, let's dive into today's topic: understanding tenant responsibilities for minor repairs. Now, we all know how important it is to keep our homes in tip-top shape, but sometimes it can be confusing figuring out what falls under your responsibility versus the landlord's. Let's break this down step by step so you're clear on what you need to do. First things first, if something breaks or needs fixing that directly affects the day-to-day living conditions of your home, like a leaky faucet or a squeaky door hinge, chances are it's your job to fix it promptly. These are minor repairs and not big-ticket items that might require professional help from your landlord. Think about it this way: if you notice something isn't quite right, and it's something you can reasonably handle yourself, then it's probably on you. Now, let's talk about the nitty-gritty details of how to approach these minor repairs. When you identify a small issue that needs attention, don't just ignore it or hope it'll go away on its own. The sooner you address it, the less likely it is to become a bigger problem down the road. You might want to keep a handy toolkit around for those quick fixes. Things like screws, nails, and basic tools can be invaluable. Next up, remember that communication with your landlord or property manager is key when dealing with repairs. If you're unsure whether something falls under your responsibility or theirs, it's best to ask rather than assume. A simple message or call can save you from unnecessary hassle and potential disputes in the future. Lastly, maintaining a log of all minor repairs you've done yourself might be helpful for record-keeping purposes. This way, if there are any questions about what has been fixed over time, you have evidence to back it up. So, to sum it all up, take care of those minor repairs yourself when you can, communicate regularly with your landlord or property manager, and keep a log of the work done. By doing so, you're not only ensuring your home stays in great shape, but also maintaining a positive relationship with your landlord. All right, let's dive into the world of landlord obligations when it comes to major repairs. When we talk about landlords and their responsibilities, one key area is ensuring that properties are well maintained and safe for tenants. So today, we're going to focus specifically on what landlords must do regarding high-ticket items, those bigger repairs that can't be ignored. First off, let's clarify what constitutes a major repair. These aren't just the usual wear and tear fixes like replacing light bulbs or tightening loose handles. We're talking about structural issues, electrical malfunctions, plumbing problems, and other significant maintenance tasks that could impact safety or habitability. Now, every landlord knows these repairs are inevitable, but it's crucial to understand their legal obligations. In many jurisdictions, landlords have a duty to perform regular inspections and make necessary repairs promptly. This means if they find something wrong during one of those routine checks, they're responsible for fixing it without delay. But what about when tenants report issues? The landlord must address these too timely and effectively. There's nothing worse than a tenant feeling unsafe because the landlord hasn't acted on their concerns. Now, let's talk about how landlords should approach major repairs. They need to be proactive, not reactive. Regular maintenance can prevent big problems from cropping up suddenly. It also shows tenants that they're being taken care of and valued as residents. When it comes to handling these repairs, communication is key. Letting your tenant know what work needs doing and how you plan to handle it builds trust and keeps everyone informed. Another important point is the cost of major repairs. Landlords need to budget for unexpected expenses because these things don't always follow a schedule. It's wise to have savings set aside specifically for such emergencies. This way, when something breaks that requires immediate attention, there's no delay caused by financial planning. Lastly, landlords should also consider working with reliable contractors who can be trusted to do the job right and on time. Building those professional relationships can make handling repairs much smoother in the long run. So, wrapping up, remember these key points. Landlords must inspect regularly, address both tenant-reported issues and routine maintenance needs quickly, budget for unexpected expenses, and collaborate effectively with contractors. By staying on top of these responsibilities, landlords can ensure their properties remain safe and habitable while maintaining positive relationships with tenants. Today, we're diving into one of those important legal topics that can affect anyone's life: legal grounds for eviction. Now, eviction isn't just about not paying rent on time. There are several reasons why a landlord might need to kick someone out. Let's start by understanding what constitutes a legal ground for eviction. First off, non-payment of rent is probably the most common reason landlords seek eviction. If you're consistently late with your payments or skip them entirely, the landlord can initiate eviction proceedings. Another ground could be violating lease terms. For example, if your lease states that pets aren't allowed but you decide to bring in a furry friend anyway, that's grounds for legal action. Additionally, illegal activities on the premises are another major reason landlords might want to evict someone. This includes anything from drug dealing to hosting loud parties late into the night. It's important to note that even if it's just one incident, it can be enough to kick you out. Another ground is when the landlord decides to sell or renovate the property. In such cases, they might give notice to tenants that their lease will end early. This usually happens with commercial properties more than residential ones, but it's worth mentioning nonetheless. Now, there are also legal protections for tenants in place. Many states have laws that require landlords to provide a certain amount of notice before evicting someone. For example, they might need to give you 30 days notice if you're renting long-term, or even longer if the lease is month-to-month. So, when facing eviction, it's crucial to know your rights and responsibilities as outlined in your lease agreement and local laws. Understanding these legal grounds can help tenants stay informed about their situation and potentially negotiate with landlords for better terms or extensions. In conclusion, while eviction isn't always a pleasant topic, being aware of the legal grounds can empower you as a tenant to navigate any potential issues head-on. Today, we're diving into the eviction process, an important topic for landlords and tenants alike. Let's break it down step by step to understand what happens when things don't go smoothly in a rental agreement. First off, every eviction starts with a problem between landlord and tenant. This could be late rent payments, damage to the property, violation of lease terms, or other issues that aren't being resolved amicably. When these problems arise, the landlord needs to formally notify the tenant about their intention to evict them. This is typically done through a formal notice letter. Next comes the legal notice period. Depending on state laws, landlords must give tenants plenty of time to either fix the issue or vacate the premises before eviction proceedings begin. For example, if rent hasn't been paid, they might need to provide a 3-day notice. After that, if the tenant doesn't address the problem within the given time frame, the landlord can file for an eviction lawsuit in court. This is where things start getting formal and legal. The tenant will receive official paperwork from the court advising them of the upcoming hearing date. At the eviction hearing, both parties present their side to a judge or magistrate. The landlord must provide proof that all steps were correctly followed according to state laws and local ordinances. If the judge sides with the landlord, they'll issue an order for eviction. The final step is the actual eviction. Law enforcement will come to enforce the court's decision if the tenant hasn't moved out by then. This can be a stressful time for both parties involved, but is necessary to resolve disputes fairly and legally. Throughout this process, communication remains key. Both landlords and tenants should aim to solve issues early on to avoid costly legal battles and unnecessary stress. Understanding these steps helps everyone navigate the eviction process more smoothly, protecting their rights and interests. That's it for today's lesson on the eviction process. Remember, staying informed about your local laws and communicating clearly can help prevent many headaches down the road. Let's dive right into how we can improve our written communication skills when dealing with tenants. Effective writing is key to building strong relationships and ensuring everyone is on the same page. Start by thinking about who your audience is and what they need from you. Are they looking for quick answers or detailed explanations? Tailoring your message helps a lot. When it comes to emails, always aim for clarity and conciseness. Use short sentences and bullet points when listing things. For instance, if you're sending an email about rent payments, say something like, "Reminder, please pay your rent by the first of every month to avoid late fees." This makes it easy for tenants to understand what they need to do. Another important aspect is tone. Keep it friendly but professional. You want to convey warmth and approachability without being too casual. For example, instead of saying "Hey there," you might start with "Dear Tenant's name." It's that simple touch that makes a difference. Also, proofreading your messages before sending them out can prevent misunderstandings down the line. A quick read-through helps catch any typos or unclear sentences. Think about it. If your message isn't clear, tenants may have questions or even get confused and stressed out. That's not what we want. Lastly, remember to follow up on important emails. If you send a notice for maintenance work, make sure to check back later to see if they received the message and understood what was needed from them. This shows that you care about their experience and are there to help. So, in summary, know your audience, keep it clear and concise, maintain a friendly yet professional tone, proofread before sending, and follow up when necessary. These tips will go a long way toward improving written communication with tenants and making everyone's lives easier. Today, we're diving into how to manage tenant complaints and feedback effectively. It's crucial for any landlord or property manager to understand how to handle these situations smoothly because it directly impacts tenant satisfaction and loyalty. Let's break this down step by step. First, listen actively when a complaint is made. This means really paying attention to what your tenant has to say without interrupting them. Show empathy and understanding even if you think the issue isn't serious. Acknowledging their concerns shows respect and helps build trust. Next, document everything thoroughly. Write down the date of the complaint, who it came from, exactly what they said, and any actions taken or promised. This is important for future reference and to ensure no detail is missed in resolving the issue. Then, take immediate action if you can. If it's something simple like a broken light bulb, fixing it quickly shows responsiveness. For more complex issues, communicate clearly about when things will be addressed and follow through on your promises. It's also important to maintain open lines of communication throughout the process. Keep tenants updated regularly, even for ongoing problems. Let them know what steps are being taken and why certain actions might take longer than expected. This transparency helps manage expectations and reduces frustration. Lastly, after addressing a complaint, reach out to thank your tenant for bringing it to your attention. This shows appreciation for their honesty and feedback, encouraging more open communication in the future. Remember, managing complaints effectively isn't just about solving problems. It's also an opportunity to strengthen relationships with tenants and improve overall property management practices. By listening carefully, acting promptly, communicating openly, and showing gratitude, you can turn even tough situations into positive experiences for everyone involved. That wraps up our discussion on managing tenant complaints and feedback. Let's dive into the world of routine inspections and maintenance, because keeping things running smoothly is key to success in any business environment. Picture this. You've got a high-ticket item that needs regular care to perform at its best. Whether it's machinery, vehicles, or even IT systems, scheduling these routine checks can save you from big headaches down the line. First up, let's talk about why we need these inspections. Think of your car's oil change. If you skip it, everything might seem fine until suddenly your engine overheats or grinds to a halt. The same goes for bigger assets like HVAC systems or heavy machinery. Regular maintenance can spot potential issues early on and prevent costly breakdowns. Next, Let's break down the process into manageable steps. Start by identifying all the assets that require routine inspections. Make a list with each item's specifications and how often it needs to be checked. For instance, you might need to inspect your fire safety equipment every 6 months or check your IT infrastructure quarterly. Once you have this list, map out a schedule that fits within your operations downtime and ensures everything gets the attention it needs. Now, let's talk about assigning responsibilities. Who will do these inspections? It could be in-house staff or external contractors, depending on expertise required and resources available. Make sure everyone knows their role and is trained properly for the job. Keeping records of each inspection is also crucial. This way you've got a history to refer back to if needed. Lastly, don't forget about setting reminders. Use tools like calendars or software that can alert you before scheduled inspections are due. This helps ensure nothing slips through the cracks and everything stays on track. Regular follow-ups can also help maintain consistency over time as staff members change or systems evolve. In conclusion, scheduling routine inspections and maintenance is all about planning ahead and staying proactive. By identifying your assets, creating a clear schedule, assigning responsibilities properly, and setting reminders, you'll be well equipped to keep everything running smoothly without surprises. Today, we're diving into the world of positive landlord-tenant relationships. It's all about creating an environment where both parties can thrive. So let's start by understanding why fostering good communication is key. When landlords and tenants talk regularly, it builds trust and helps address any issues early on. For instance, if a tenant notices something needs fixing, they're more likely to report it sooner rather than wait until the problem worsens. Another important aspect is being responsive to maintenance requests. High-ticket items like HVAC systems or roof repairs can be intimidating, but addressing them quickly shows tenants you care about their living conditions. Plus, regular upkeep prevents small issues from becoming big headaches down the line. Financial transparency also plays a crucial role in building trust. Landlords should clearly communicate rental prices, security deposit policies, and any unexpected costs upfront. This way, everyone is on the same page when it comes to money matters. And don't forget about leases. Make sure they're fair and easy to understand for both sides. Now let's talk about flexibility. Sometimes tenants face hardships like job loss or medical emergencies. Being flexible with lease terms shows compassion and can prevent eviction rates from rising unnecessarily. It's all about working together during tough times. Lastly, respect goes a long way in any relationship. Whether it's respecting privacy by giving proper notice before entering the property or showing appreciation for responsible tenants, mutual respect creates a positive atmosphere that benefits everyone involved. So there you have it, folks. By focusing on communication, responsiveness, financial transparency, flexibility, and respect, landlords and tenants can build lasting relationships filled with trust and cooperation. Thank you all for joining me on this journey through the intricate world of landlord-tenant relationships management. We've covered many essential topics together, from understanding your legal responsibilities and tenant rights to crafting comprehensive lease agreements and handling security deposits. You've learned about the importance of clear communication strategies and how to manage maintenance and repairs effectively. We also explored eviction procedures and best practices for property management. These lessons are crucial not only for navigating legal obligations, but also for building positive, long-lasting relationships with your tenants. The most important takeaways from this course are to always maintain open lines of communication, stay informed about local laws and regulations, and treat your tenants fairly and respectfully. By applying these principles, you'll be better equipped to handle any challenges that arise in managing rental properties and fostering a positive living environment for everyone involved. I encourage each one of you to put what you've learned into practice. Whether you're an experienced landlord or just starting out, these strategies will help you manage your responsibilities more effectively and create a harmonious home for your tenants. As we conclude this course, I wish you all the best in your future endeavors as landlords or property managers. Remember that success often comes from continuous learning and improvement. Don't hesitate to reach out if you have any questions or need further guidance. Lastly, please consider connecting with me or leaving a review about your experience here at the end of this course. Thank you once again for taking part in this journey.